Labor standards provisions have become a new typical component of the EU's free trade agreements since the initial signing of the EU free trade agreement with Korea and with South Korea in 2009. Those provisions are contained in dedicated chapters, the so-called Trade and Sustainable Development chapters, and they are present as key elements of the EU's commitment to a value-based trade agenda. And in fact, in its strategic plan for 2016-2020, the DG Trade recognized that trade policy must promote sustainable economic, environmental, and social conditions, and stressed the importance of the use of strong provisions to promote the respect of labor rights. The idea behind the Trade and Sustainable Development chapters is to improve working conditions and rights at work on the ground, to make global supply chains more responsible, and to contribute to achieving sustainable development through the free trade agreement itself. The essential common aspects of the trade and sustainable development chapters of multiple EU free trade agreements are the following and concern mainly substantive labor rights, standards, procedural commitments, institutional structures, and the way the complaints are to be handled. In terms of substantive standards, under these agreements the parties make commitments in relation to the International Labour Organization's core labor conventions included in the 1998 Declaration of Fundamental Principles and Rights at Work. These conventions mainly deal with the freedom of association and collective bargaining, and forced and compulsory labor, the child labor, and workplace-related discrimination. The substantive standards are accompanied by a set of procedural commitments, including those on dialogue and cooperation, for example, or the need to monitor and review the sustainability impacts of the agreement, or the need to uphold a level of protection in relation to labor standards. And in terms of the institutional structures, the Trade and Sustainable Development chapters include the establishment of a joint committee of representatives and a civil society mechanism. The joint committee of representatives includes representatives of the two parties and has to oversee the implementation of this specific chapter, while the civil society mechanism brings together representatives of business, NGOs, and trade unions. However, it is important to underscore that complaints concerning the implementation of trade and sustainable development chapters are not covered by the Trade Agreement's General Dispute Settlement Mechanism. Indeed, Trade Sustainable Development chapters contain their own dispute resolution mechanism consisting of, first, government consultations and, if necessary, the establishment of a panel of experts. Now, focusing on the free trade agreement between the European Union and South Korea, the very point regards Article 13, Paragraph 4. Article 13, Paragraph 4 lists the commitments that the parties have to follow with respect to labor standards. They mainly include ratifying and effectively implementing some ILO conventions concerning international labor standards, and setting domestic and legal guarantees on the freedom of association and the right to collective bargaining. The European Union considers that the action taken by Korea under this point of view are insufficient. And so, the European Union in December 2018 decided to request government consultations on trade and sustainable development chapter of the EU-FTA with South Korea. Those consultations took place at the beginning of 2019, on the 21st of January, and after that, after more than 90 days, thereby following Article 13, point 15 of the EU-Korea Free Trade Agreement, the Commission expressed the intention to convene a panel of experts to examine the matters that have not been satisfactorily addressed through government consultation. Basically, the European Commission decided to start the second phase of the whole procedure. The core issues that the panel will probably have to explore are the following. First of all, the panel will have to address the matter in the absence of specific rules of procedure applicable before it, since they have not been agreed upon between the contracting parties. Then it will be necessary for the panel to clarify the nature and scope of application of the Trade and Sustainable Development chapter, in particular by focusing on the social dimension of this chapter. It will be interesting also to highlight the provision of Article 13.4, which specifies that continued and sustained efforts must be made towards ratifying the Fundamental ILO Convention, and in particular it will be important to conclude whether these efforts represent an obligation of conduct or an obligation of result. Then, if Korea does not comply with its commitments in a timely manner, the panel of experts will probably deliver a public report with recommendations to get Korea achieving compliance. And the implementation of the recommendations of the panel report will be then monitored by the Trade and Sustainable Development Committee created under the terms of the EU-Korea Free Trade Agreement.